Good evening. This is Rahul Reddy live here from Houston, Texas. Along with me is my business partner. Emily, what are we discussing today?
All right, we wanted to talk about filing again in EB2 or refiling. As you've seen, the December visa bulletin came out yesterday. Dates of filing moved forward. We don't know yet if we'll be able to use those, but a lot of people are wondering if they downgraded to EB3 last year, does it make sense to get back into EB2 now? And if so, what's the best way to do it, interfiling or refiling? We also want to share the news about our class action lawsuit that what allowed the settlement to happen for H4 and L2 EADs. We'll talk about that, who it helps, who it doesn't help, what we still have going on. Also, we've talked time and again about this budget reconciliation and how the plan is to get some sort of immigration reform passed through that process because it doesn't require the majority, the 60 votes. We can get it through without the filibuster. What is the status of that? When might we actually see something happening, and what will actually be included in it? Also want to talk about using that green card EAD. When is it safe to do it? When should you stick with the H1B or your underlying status? And again, talk more about interfiling and refiling and answer all your questions there.
Emily, there are a lot of lawyers that are telling that once your adjustment of status is pending, you cannot file one more 485 or adjustment of status application. Is that right?
No, and I'm really surprised the number of times I'm hearing that. You know, we do consultations every day, multiple a day.
And we do have Zoom conferences every single day. We have YouTube, we have TV Asia, yeah.
And time and again, people say, well, my attorney told me I can't file another 485. We're prohibited from doing that. That's just simply not true. And then, of course, the next question is, well, how do I convince them? Where in the law does it say that you can file another 485?
Isn't it the same people who said that you can't file an amendment? You can't file a downgrade application only?
Right, exactly.
Isn't it the same people who said that you have to file only amendment, you cannot file as a new application, the I-140?
Yes, and you know, for example, one of my consultations coming up, the attorney said, well, I've been doing this for 20 years and I've never filed two 485s for someone. Well, that doesn't mean you can't do it, it's just you haven't tried it. So I think there's a lot of that out there. There's nothing in the law that restricts someone from filing only one 485 as long as you're eligible for it. So if you're eligible in EB2, EB3, or maybe you're eligible and your spouse is eligible, you can file multiple 485s. They can be pending at the same time. Once they're ready to approve one, whichever one happens to be fastest, they usually will ask you to withdraw the other one, and there's no problem with that.
Emily, if for filing the second I-485, what are the conditions that people need to follow though?
Yeah, most importantly, you have to be maintaining your non-immigrant status. So if you've already filed the first 485, after that, you need to continue to maintain your H1 or your L1 or your H4 or L2, and all of your family members need to be able to continue to maintain that status so that you can file that second 485, because you have to qualify for adjustment of status as if you've never filed before. On top of that, your employer still needs to be willing to file that second 485. Now, of course, it's your application, but the employer has to submit a supplement J confirming that they're still offering you that job. So if you've moved on to a new employer, it may not be possible for you to do the interfiling.
So let's discuss more about the pros and cons of interfiling with the new development, with all the questions that are coming. Even though we did a separate 10-minute thing, people are asking so many questions. New kind of questions are coming, Emily. So let's discuss first about refiling the application, pros and cons. One of the disadvantages definitely is that the money wise, it's more expenditure compared to interfiling. To refile the entire application, it's more expenditure. That's one thing. The second thing is that you still need the company approval to do the refiling application. You are starting the 485 application all over again. That's another thing. And if you are moving to different section like EB2, from EB2 and you're refiling it, you still have to wait for 180 days if you want to change the job. Otherwise, you're going to lose the refiling application. These are some of the cons that I see. What are the advantages of refiling, Emily?
Well, you may end up at a different service center for those people that did the downgrade plus the 485, where everybody ended up at the Texas Service Center and everybody is still pending. We're seeing a lot of the standalone 485s going to the National Benefits Center instead, which does seem to have a faster processing time. I've got one that I filed last month. I already received an RFE asking for the birth certificate because we didn't have it at the time. 30 days, we get an RFE. They've already looked at the file. So that is definitely a benefit, getting to a different service center. Obviously, if the EB2 dates continue to move forward where your final action date becomes current before the EB3 final action date would have, then you may likely receive the green card faster by doing that refiling, even though it puts you in the back of the line, because the line also takes into account the fact that your final action date may not be current in EB3.
Emily, what if in the refiling, the EB2 goes back and EB3 goes forward? What will happen at that time?
Well, the good news is by refiling, you're covered both ways. You've got one application, you've got 1 foot in on each boat, and whichever one happens to leave the dock earliest, you can jump on that boat and stick with it.
Do I have to file an EAD in advance parole in the refiling again?
It's never mandatory to file an EAD in advance parole, but I definitely recommend it, especially because there's no additional cost to you. There's no filing fee, because you don't want to worry about, okay, can I use this EAD but not that EAD because of different considerations to think about. So I would definitely file a second EAD.
And I also recommend to file the medical, even though it's not mandatory. There is a chance they may not use your biometrics that you have done before. They may request you to do the biometrics again. There's a chance for it. I just want to let you know all the cons and plus and the pros of refiling. Any other things that I'm missing, Emily?
I think also with the refiling, one of the benefits is there's an actual application that you're filing with a filing fee. That means USCIS has to process it and give you a receipt notice. You do not get that with interfiling. You have no way of confirming with interfiling whether they've actually done it or not. So that's one of the major benefits, is you actually have a case number, you can follow the processing times and keep track of what's going on with the second filing.
Let's discuss about interfiling, Emily. What are the advantages of interfiling?
Definitely less expensive because there's no filing fee for that process. You don't have to do the medical again. You don't have to do the biometrics again. You're basically asking them to take your existing 485 and convert it from EB3 into EB2 based on this I-140 approval notice that you're submitting. What
if in the refiling, EB2 moves back and EB3 moves forward? Can I re-interfile it?
The interfiling, I think it'd be very difficult to switch back again. The USCIS doesn't really have a lot of guidance there. There's some question about whether you can even do it, but interfiling, it's really important to remember that it's discretionary with USCIS. They can choose not to let you do it if it's going to be too difficult for the agency to accommodate your request. So it's already difficult to do it once. To have them go back and do it again, I think would be practically impossible.
One thing is that it's not a formal process. There is no filing fees. There is no receipt notice for interfiling. These are the these are the cons of the interfiling, though, that people need to be aware of. Typically, the time process takes a long time. After a couple of congressional inquiries, it may happen. A lot of clients that come and ask me, Emily, can you interfile me? I will do interfiling, but one thing I will not do is that follow up on the interfile and get the green card based on the interfiling, because that takes forever, and sometimes 5-6 years it takes for them to get that thing. So that's a problem, though. But at the same time, Emily, what if the persons have been in advance parole, use the EAD? At that point of time, they cannot refile it. They may have to do interfiling only.
Right. Yeah, because for the refiling, remember, you have to be continuing to maintain your non-immigrant status to be eligible for that. So if you have used the EAD, or your spouse has, or your child, you've got a teenage kid and they want to work for the summer, if anyone's used that EAD, refiling is not going to be an option for you, at least not an easy one. So interfiling may be your only chance to get into the EB2 category.
Anything else before we move to the next topic?
I think we covered everything.
The H4 EAD litigation, you have been telling all along that they are going to get the H4 EAD faster. Now, we didn't get the H4 EAD to the extent what is happened. Why did you compromise with the USCIS? Why did Stephen Brown compromise with the USCIS?
Right, and this is really a first step. There's actually 2 lawsuits going on, and it's a little bit easier to get the low-hanging fruit. It's clear in the statute the correct way, I think, to interpret it, and what we were arguing for the L2s is that they don't even need an EAD at all. And why can't you provide this auto extension for those people that already have the status approved? Because when they created the H4 EAD by regulation, in the comments to that, they actually addressed that and said, we can't do auto extensions because we can't be sure that that person's status is going to be extended. Well, if you have an I-94 where it was extended, then you should be able to do it, right? If you said you can't do it because of this reason, well, if we eliminate that reason, you should be able to do it. So this was a very targeted lawsuit meant to get that quick win while we still work on the other lawsuit that's going on that is really trying to address the I-539 processing times. But remember, even though you may not directly benefit from the settlement that we have now, you indirectly will, because now USCIS doesn't have to adjudicate any L2 EADs. They can spend their time adjudicating H4 EADs and get caught up with that backlog and make those processing times much more reasonable.
Emily, so let's run into scenario though. My H4 and EAD is expiring in December of 2021. I filed my extension of H4 and EAD. Now, can I continue working after December right now under this one?
No, assuming that your H4 status also expired in December 2021. So it only works if your H4 is extended already beyond the EAD validity. So here's the perfect scenario where this helps. 2 of them actually. Number 1 would be the H1B files at the 6-month mark to get the renewal in premium processing. As soon as that gets approved, the H4 exits. Use the H1B approval notice to get the visa stamp and come back in on H4. Now you've got the extended H4, then you can immediately turn around and file that EAD renewal. Now you get the 6-month auto extension to hopefully, and you're not dealing with the I-539 processing time, you're dealing with the standalone I-765 processing time. It also can work in the situation where you filed an H-1B transfer, maybe several months or even a year before your current status expired, and you included the H-4 extension at that time, but did not do the EAD extension. In that situation, you have the extended I-94 and then can benefit when you do finally file your EAD renewal.
Emily, let's discuss about the House is expected to pass the budget reconciliation, also called as Build Back Better. What do we expect in this one, in the House bill though?
Yeah, so the House bill currently has the provision that recaptures the unused green cards, which will be a huge benefit. Takes back those wasted green cards, the 80,000 that we lost last year, and also has the provision that if your priority date is 2 years old, you can early file your 485 and not be subject to the cap. So those things are going to be a huge benefit. Those are all in the House bill. And right now we're waiting for the CBO to come out with its score of this bill and how it actually impacts our country's finances. That's now supposed to come out on Friday, which means that we may have the House voting on this bill on Saturday. So that's the House side. The Senate, though, we've been saying for I don't know how many weeks that the Senate is going to give the parliamentarian their Plan C and see what the parliamentarian said. And we've been waiting and thought we had confirmation that that happened. Now we find out, no, the Senate wants to wait until the CBO score comes out on Friday, and then they will give Plan C to the parliamentarian. It doesn't seem like they're including any of the employment-based provisions when they're giving these different plans to the parliamentarian. That doesn't mean they're not going to include it in the final bill. But we just know it sounds like they don't want to muddy the waters. They have all kinds of excuses for these things. So the Senate side, they're now saying that they may try to pass something, the budget reconciliation bill, by Christmas. So we may have the House pass it this weekend. Senate's going to take time. We don't know what's going to be in the Senate bill. and that may not happen until Christmas.
We would like all the people to contact the congressmen and the senators. If you have not already done it, we have provided a link at the bottom of the we have provided a link in this at the bottom of the video where you can a draft has been provided for you to contact the congressman. Emily, let's go to the question and answers.
Yeah, well, we were going to talk about when it's safe to use that green card EAD.
Yeah, we have covered that in the last video where we've said what are the pluses and minuses on those. I want people to watch that video because that's pretty much covered the 10 minutes on the. We'll try to put a link of that video there, Emily, unless you have extra comments more than that.
Oh, that sounds good.
Let's go to the questions. Questions are asking receipt notices. Yeah, that's a nightmare right now. Receipt notices. It is taking almost about one. There are some cases that are pending from past 2 months that we didn't receive the receipt notices though. But some of the cases there we have received the receipt notices which are about a month or so. But some of the cases that we have 2 months. So somewhere between 4 weeks to 8 weeks is the time that it's taking to get a receipt notice right now for the adjustment of status I'm speaking about.
All right. A couple of questions about interfiling and AC21 portability. This is from Manasa. After you interfile from EB3 to EB2, can the dependent change the employer using AC21 portability and work on the EAD? Well, let me first say, the American Immigration Lawyers Association put out a practice pointer recently that talks about AC21 and interfiling, and they recommend that after the interfiling is submitted, you wait for 180 days before you attempt to change employers using AC21. So first, if you've already used AC21 to change employers, interfiling is probably not going to be an option. Second, when you do interfile, you need to wait another 180 days before you attempt to change employers using AC21. But to this question, talking about dependents don't need AC21. Dependents, once they have an EAD, can work wherever they want, regardless. They don't use AC21. It's only to move the main applicant's green card process from the old employer to the new employer without losing your place in line and without having to file again with the new employer.
Daryl has this question. My son has used the EAD and he aged out on H4. Is it possible to use the new filing EB2? Well, the main aspect, Daryl, will be that did your kid, if the kid aged out though, I mean, he's not protected by CSPA, then you can ignore him and because he's probably an F1 visa right now, and then you can refile the application. But if he's already protected by the Child Service Protective Act, though, no, don't refile. This is not for you. You may want to check with your. You may want to seriously consider because the person who is protected, you may unprotect him. That means that you may kick him out of your application by refiling. This is not for the people whose kids are between 18 and 21. You better be very careful for refiling though. In general, my advice is that if the kid is already protected, don't do anything to refile unless the final action dates are current. And you can still protect him in the EB2, then it's a different issue, but otherwise, don't refile application.
Kunal says, I filed my concurrent downgraded filing in October 2021 and still haven't received my receipt notice. Priority date is current under EB2 date for filing in December. Would I be able to file another 485? If so, when? So I'm assuming your downgrade petition was a new petition, not an amended petition. So you already have the I-140 approval in EB2. And in that situation, assuming USCIS says we can use the filing dates, you can file the 485. Doesn't matter if you haven't received the receipts from the other one yet because they're not required to be submitted.
If the file moved to NBC, shall we try interfile or refile if eligible for same? I want you to watch the first 15 minutes of our video. You'll get an idea of what is better. Just because it moved to NBC doesn't make any difference though.
Harry says, if we apply for an EB2 AOS and leave the US for a few months, will the AOS be abandoned? Possibly. It depends on your situation. So the general rule is Once you file a 485, if you leave while it's pending, it's abandoned unless you have an approved advance parole when you leave and when you come back. That's the general rule. Now there's a special rule for H and L visa holders that says once you file the 485, if you are maintaining H1B or L1 or H4 or L2 status at the time you leave and you come back in the same H or L status, you do not abandon the adjustment of status even if you don't have an approved advance parole.
Jawahar is saying, congrats on winning the class action. Thank you for your time and effort helping L2s and H4 holders. Well, here is Jawahar. Let's not, don't celebrate the victory until we go to the finish line though. Right now, there are 2 class action suits. We only settled, only one thing we won. The second one is still there. This is not the full extent of what the full extent that we would want to achieve. The second one is still pending. It's going to be ruled on the merits. Let's see. Let's hope so the judge rule in our favor though. So let's not celebrate yet.
Prashanthi is currently on H1, just got it from October 2021, and wants to know, can she switch back to H4, which is valid till 2023 while she's still in the US, and the previous H4 EAD, is it still valid? Can I use it? So you can switch back to H4. There's 2 ways to do it, a fast way and a slow way. The slow way is to file a change of status from H1B to H4 with USCIS on the I-539 and wait a year for that to be processed, and you may be able to continue working on your H1 if you still have that job while you're waiting. The other way to do it is automatic revalidation, assuming your H4 visa stamp has expired. You can go to Canada or Mexico and come back in showing your previous H4 I-94 and your H4 visa stamp, even if it's expired. And then once you're in H4 status, yes, you can use that H4 EAD that has not expired.
Sam has this question. Do I need to notify the National Visa Center if I am processing the adjustment of status? Previously, I-140 has been filed under the consular processing. You're under no obligation to do it, but it's always better to inform them, NVC, that's saying that, look, buddy, I'm actually filing in the adjustment of status, so don't keep bugging me about getting the green card in the consular processing. So it's always better, but it's not absolutely required. You can just file the adjustment of status, ignoring the NVC, absolutely not a problem.
Shankar wants to know, can the DS-160 be filled out or modified after scheduling the visa stamping appointment in India, Mexico, or Canada? No. Once you fill out that DS-160, because you do that first before you can schedule your appointment, that's locked in. It's not possible to make modifications to it after you submit it.
Naga has this question. Infrastructure bill has passed. Is there any chance of passing the Build Back Better bill? The infrastructure was a bipartisan bill. There were 69 senators which voted in favor of the bill out of the 100 though. 19 Republicans voted in favor of the infrastructure bill. When it comes to the Build Back Better bill though, none of the Republican senators are on board to vote, at least not to my knowledge though. So that's the major hurdle though. House is not the thing, it's a Senate. The second thing is that the bill, if it's not a budget bill though, it should have a majority of 60 votes to pass through the Senate. Now, since it is definitely a budget bill, but the problem is that what some of the, I wouldn't say that some of the Democratic senators, but it is the parliamentarian which they appointed is putting an objection saying that, look, immigration is not part of the budget, so it should not be included. That's where, Naga, the problem is coming for us. Because if it's a budget bill, we don't need 60 votes, we only need 51 votes, which the Democrats seems to be having. Because there's always 2 or 3 senators who are trying to say, well, we need this, we need that, but looks like they are on board right now. No guarantees to it, but at least no Republicans are supporting at this point of time. So it's a little bit tougher, or I would say that much more tougher then the infrastructure bill. That's the reason we need to put a pressure on the senators to include our part of it, though. Because if you look into it, they're trying to include the DACA provisions, but they're not that much emphasizing on the employment based. That's right, because we don't have much voices. We need to contact our senators. Even though you may or may not be, even though you're not a U.S. citizen, you can still write letters to senators, and we have provided the draft of it. This is a time, because most probably by end of this year, something is going to happen. Whether good or bad, it depends on how much lobby effort we can do. I mean, we can do our own efforts, and we'll see how the senators are going to act on it.
Manoj says, I first filed the 485 as an EB3 downgrade with me as the primary and my spouse as a derivative. If my spouse loses her job on the H1B and moves to H4, can I still file a second EB2 485? Yes, you can. It doesn't matter. You don't have to keep the same status that you had when filing the original 485. You just have to keep a non-immigrant status.
Shivram has this, Saranan Shelvraj has this question. Checking to see I-9 requirement, is it the employer's responsibility or employee's responsibility? It is definitely an employer's responsibility. As far as you as an employee, Mr. Shelvraj, you need to be in legal status to work for that particular employer, though. So you have to make sure that's your responsibility, though. If the employer does any mistake in the paperwork, that's fine. He will be the one who will be suffering. As an employee, though, if you are not authorized to work for the employer, you will still be getting punishment, though, because then you will be prohibited in some of the immigration benefits because you worked unlawfully in this country. So just make sure that you, from your side, you are taking care of it, that you're working for the company that for which you have been authorized for. As far as you are good in it, you will not be punished under any circumstances if you are legally authorized to work for that employer.
Raj has a priority date in 2014 in EB3, received the EAD and AP. He's planning to switch employers and wants to know, do I need to file the I-485J supplement before switching to the new employer? No, it's not mandatory to submit it before you start working. It's not like an H-1B transfer where that has to be filed before you can start working. It can be submitted anytime after you join that company.
Question, Shankar, can DS-160 be can DS-160 be modified after scheduling the visa appointment? You can try to log in and modify it. If it's mere clerical things like address and certain clerical things, though, you can, if it doesn't allow you, you can send an email to the consulate telling that, look, this is my application number. There is an error in the address, so this is my actual address. Some clerical things, that's fine. But let's say, for example, you filed, you're trying to get a H-1B visa for, company Pepsi, but now you're actually going to get it from Coca-Cola, though. Then don't. The reason is that they've already done all their work on Pepsi. Now you're telling it's Coca-Cola. They don't have that information there. So definitely at that point of time, I want you to withdraw the application and refile one more DS-160 if it doesn't allow you to amend it.
Elongo has an H1B, H4, and H4 EAD valid until December. The extension's been filed and wants to know if the H1 is approved, but the H4 is not yet approved. Can I travel to Mexico before December for H4 stamping? Is there any impact on the already filed H4 and EAD? So assuming you can get a visa interview in Mexico, because that's going to be a problem right now, but once the H-1B is approved, the H-4 spouse can choose to exit and apply for the H-4 stamp at a consulate and then come back in rather than waiting for the H-4 application to be approved, assuming that this is an H-4 extension, not a change of status to H-4. If the H-4 spouse filed a change of status, when you exit, it will be abandoned and it can lead to the abandonment of the EAD. But an extension, yes, you can travel, get the stamp, and come back in. Once you're back in, it's really important to send your new I-94 details to the EAD application so that you can ask them to adjudicate your EAD faster based on the fact that you already have EAD H-4 status extended.
Harry has this question. can he stay in outside the country for a long period of time once the adjustment of status has been filed? No, you cannot. If you are considering anything more than 3 months, definitely check with your lawyer before. That's a very great danger. Abdul has this question. The final action date has been current. It's almost 3 months and his green card, he did not get the green card. There are two things, Abdul. One is that the final action date has to be current, and the processing time also should be current though. If the processing time has passed your date, and if your final action date is current though, you may want to raise a service request with USCIS. You may want to contact the local congressman. You may want to contact the ombudsman to have your application adjudicated. But both the processing time and the final action date, both have to be current for you to contract.
Chandra is currently in India, was previously in the US on H-1B for 3 years, then came back to India because the extension wasn't done in 2017. Wants to know, can I still be eligible to come to the US again with the same H-1B? Well, it's not necessarily the same H-1B, but you are considered to be counted in the cap, and any employer can file a new H-1B petition on your behalf without going through the lottery, and you can get the remaining 3 years that you had left of your initial 6-year limit once you go for stamping and come back in. Your other option, if you wanted to, if you've been out of the US for more than 1 year, you can go through the lottery so you get a fresh 6 years. So you either can recapture the remainder of the 6 years by not going through the lottery and filing at any time, or go through the lottery, and if you're selected, you actually get a fresh 6 years.
Srini is saying that he has concurrently filed for EB3 and downgrade in Texas Service Center. I think so. He's saying about in 9/24. I mean, I'm assuming that October. There are people who filed in October of 2020 that still did not get the biometrics. So I don't know if you have filed before October of 2020. Seems that you said 9/24. That means that most probably it's 9/24 of 2021. That's normal that you did not get the biometrics. Even though Emily may have stated that one of our client got it, RFR doesn't mean that everybody got it though. It's only some of the people that got it. One question from Subbu Palniswamy from Facebook. I got my EAD, and if my company gets sold, goes out of business before I get the green card, is there any issue? Assuming that your I-140 is approved, assuming that it's more than 180 days that you file the 485, which seems to be more likely because you got an EAD under the current circumstances, if you get a different job offer though in a similar lines, it doesn't matter if your previous company goes out of business. It doesn't matter. You're fine. You will still get the green card.
Abhishek filed a 485 in EB3 with his wife as the primary and him as the derivative back in October. Now his filing dates are current in EB2. The attorney is recommending that they withdraw the first application in order to file the second application, or once you receive the receipt from the second application, to avoid confusing the officer, and they may approve the wrong application. Well, at this point, there is no wrong application. If it's faster for the EB3 to be approved, let them process that and approve it in EB3. If the EB2 happens to be faster, let them process that in EB2. It doesn't make one or the other wrong, and there's no requirement to do that. I have not seen officers get confused on that. I suppose it could happen, but we don't see it happen on such a regular basis where we would say, no, don't do that. Most of the time it is much faster to do a refiling and get that process, especially if you can get it to the National Benefit Center.
Shankar has this question. I'm working from home. Client mentioned in the DS-160. Can I mention my home address, and is that going to create any problem? If the LCA has your home address, though, definitely, I don't see any problem whatsoever at all. The consulates now understand a lot of people are working from home. Even before this pandemic happened, people were working from home, especially in the IT sector of people. You're lucky enough to have that pleasure and luxury to work from home. And it's perfectly okay for you to mention the house address as a work address.
RODS did the EB3 downgrade in October 2020. That date is now retrogressed, but will be current in EB2 in December, and wants to know, I have a job offer. Can I change the job, and can the new company file the interfiling in EB2? Or if I interfile with the current company, should I wait 180 days to change the job? Yeah, only the company that sponsored the old I-140 can assist you with the interfiling. You can't interfile with a new job offer. And if you do go ahead with that interfile with the current company, you have to wait 180 days, according to AILA's recent practice pointer, before you can change jobs.
Rati Dhanraj has this question: how long the naturalization process is taking? I will be eligible. I'll be eligible to file the naturalization process. I was being in India for 4 to 5 months due to my father's death. Will that cause any problem? As long as your stay outside the country is less than 180 days, and your total stay, that means out of the preceding 5 years, I'm assuming that you are eligible based on the 5 years. If you are physically present here for more than 2.5 years, though, out of the 5 years, and all the trips that you have made are less than 180 days. You said you were present in India for 4 to 5 months. That, according to me, is less than 180 days, which is approximately 6 months. You should not have any problem because of your 4 to 5 months stay outside the country. You should not have any problem in getting the citizenship.
Surjit has an interesting question. How does the employer's HR activate the AOS EAD? That's a good question, and it comes up quite a bit. I actually talked about this in an article that I posted today on rnlawgroup.com. There's actually nothing that anyone has to do to switch from H1B to using the EAD, because you don't have to fill out a new I-9 until you either join a new company or it's time to re-verify your existing I-9, which is when your H1B is set to expire. So the I-9 really doesn't have anything to do with it. You don't have to do anything with USCIS, so it's really kind of just in your head that you've switched to the AOS EAD in a lot of the situations.
Mayank Singh said that this 180-day rule extension of EAD is not applicable for most of the people. You're right, Mayank. It's not applicable, but as Emily has pointed out, this is there are 2 litigations. This is the first one we got actually this is the second one we got the approval. The first one is still pending. So hopefully, we all get the victory, and we all do very good. Hopefully, we are fighting for you guys.
Santosh says, for my I-140 status, it's showing name is updated. What does that mean? It probably doesn't mean the name was updated. That seems to be a catch-all status update that USCIS uses for any kind of update they do. Maybe they realized that there was a typo in the employer name when they did their data entry. They update that, correct the typo. It'll say name was updated. Maybe they updated the company's address, or maybe they updated your address after you submitted an AR-11. That could be name was updated. I've even seen where it says name updated after we submitted medicals through Interfiling. So it really just means somebody's done something and updated something in the electronic system at USCIS. Probably not your name, though.
anything but your name. Preeti has this question: if we do the new interfiling for 485A or refiling, can we still use the EB3 EAD and AP? If we do the interfiling, though, you definitely don't have any problem using the EAD and AP. If we do a new filing, though, I strictly recommend that you do not use the EAD and AP. If you have intentions to immediately use the EAD and AP, refiling may not be a better option for you.
A lot of people are asking, should I refile? Should I interfile? Should I stick it out with EB3? And the difficult thing is we really can't accurately advise which one is ultimately going to be faster, because yes, EB2 is moving forward, but as we've said many times, the EB2 and EB3 are likely to eventually flip-flop every other month to where one's faster at 1 month and the next month, now EB3 again, now it's EB2 again. That's very common. It's happened in the past with other countries. So for that reason, we can't really say that doing the interfiling or doing a refile is actually going to get you the green card faster. What it does do is give you the best chance of getting a green card as quickly as you possibly could. You've explored all options and you've done everything you could to receive the green card as fast as possible.
Yeah, and there are some people who said that my prediction is equivalent to the guy who's sitting with a parrot to pick the card on how the dates move. Yes, you're absolutely right. I mean, that is right. And that's the reason why having both options may be sometimes much better. Sometimes, not all the times, but most of the times may be much better because when you have EB3 and EB2, you have both going together. But of course, there are some drawbacks, especially using the EAD if you want to, and that's one thing that then you will have to stick with one of the things. There are some cost is a disadvantage too. So you need to consider all those aspects before you do the refiling of the application.
Abdul says, if I plan on refiling my 485, can I then travel using the AP from my first filing? What will happen to both AOS applications when I travel out of the country? So obviously you have to be in the US on the date of the refiling. Once you do that refiling, if you're in H or L status, you can exit and come back in without losing the adjustment of status, without abandoning it. Can you use the first 485's advance parole to travel after filing the second 485 if I think that's a risk. It's a very gray area. There's no guidance on that. So if you were going to do that, you may want to consider getting the H or L stamp to come back in rather than using that first advance parole to avoid abandoning the second AOS.
Ravichandra has a question. Can a person working on H4 EAD apply for a separate perm and I-140? Absolutely you can. There's no requirement that you have to be an H1B or L1 only to apply for the perm and I-140.
Anoop says, how does USCIS send an RFE? Is it one by one, or do they combine the RFEs after reviewing the whole file? Our experience is usually they send one RFE that lists everything that you need to provide. It's very rare that we get a second RFE because they missed something the first time around. When we do see a second RFE, it's usually because of the passage of time. For people whose cases they filed the 485 and then the date's retrogressed, and then 5 years later the date becomes current again, well, now we need a new medical. So even though they sent an RFE 5 years ago for whatever you were missing, they send another RFE for that. But assuming there's no kind of retrogression or long passage of time, it's usually one RFE that covers all the issues at one time.
Hassan Khan has this question. When can I leave the employment after getting the green card? Well, as soon as you get the green card, you can leave the company though. There are a lot of people, lawyers that are misinforming them. That's the way I feel it, is that because if you can leave the employment even before you get the green card on the AC-21, what is preventing you to leave it afterwards? I don't understand how the lawyers are interpreting that way. Because right now under the provisions, if you're working for company A, if it's more than 180 days that you got your adjustment of status filed and your I-140 is approved, you can leave to a different company by using the AC-21 law. Why does it prevent you that after you get the green card, you have to stay with them for 6 months? That is not true. I don't know where they are coming up. They're telling us to prove, where it is. Well, I'm telling them to prove, where does it say? And there's another thing is that, have I seen anybody's green card getting revoked or citizenship getting into trouble because they left the company after they got the green card immediately? None, zero, zip, never.
Banu wants to know, can I interfile once my filing date is current? So that will give USCIS time and get my application ready by the time the final action date is current. That sounds like a great idea from a common sense standpoint, but I don't think USCIS will go that route. The AILA practice pointer does indicate that you need to wait until your final action date is current before you attempt to interfile. The main reason for that is interfiling, again, it's discretionary and it depends on the agency's ability to move that file from one category to another. They're not going to be proactively working on a case and moving it when the date is not current. They're focused on applications where the date is current, where they can actually finally adjudicate that application. So I don't think it would be successful in getting it done any faster.
Shailaja has this question: will changing the company affect my pending 485 application? No, as long as the I-140 is approved and it's been more than 180 days that your 485 has been pending, you can. Can I still refile in EB2? No. Since now you moved out of the company, that EB2 requires the previous company's permission, so that's a problem there. That you cannot refile. You cannot even interfile also if you moved out of the company, because the I-140 doesn't belong to you. Remember that to file the 485, the company needs to cooperate. Otherwise, you cannot file the 485 by yourself.
Soundaria says, my H4 is expired, H4 and EAD extension are in progress. My employer says, since I filed the extension timely, I am good to start employment again. Is that true? No, it is not. For the H4, the auto extension only works if your H4 has already been extended beyond the validity date of your current EAD. In your situation, you said your H4 is already expired. Even though you timely filed the H4 extension and the EAD, that's not enough to get that auto extension. You're not able to work until you have the new card.
Hassan Khan, I got his question wrongly though. I misunderstood his question. Sorry about that. But let me read his question. My I-140 is pending in regular EB2, can go for premium and file 485 at the same time. Absolutely, you can do it at the same time. You're a Pakistani born citizen, so your priority date is current. Yes, you can do so. And you can apply for the advance parole and travel outside of USA. Now you can apply for advance parole, but you need to wait until the advance parole is approved before you travel outside the country though. So definitely you can file premium and 485, or the best option would be for you is to file the premium processing, wait until the I-140 is approved and file the 485. And that may be a better option for you, because since you are non-Indian, most probably the priority dates are not going to be moving backward, at least not in the next 6 months. So you could wait until the premium processing I-140 is approved.
KD wants to know, can I go to India or Mexico with the same employer, work there for 1 year, and come back to the US on H1B and file an EB1 if I'm in management? Possibly. There are a few things to unpack here. Number one, when you say go to work outside the US for the same employer, there must be a qualifying relationship between the US company and a separate company outside the US. So you can't just say go to India and work for the US employer in India for a year and qualify. So that's number one. There needs to be two separate entities in order to do a international transfer, multinational transferee. And at the second time, your position outside the US and the position you're coming back to in the US need to qualify as manager. There's a specific definition for manager. Not every manager qualifies as an EB1C manager. So it's very important, if you're considering doing that to get the green card faster, make sure that someone, an attorney that's qualified, reviews both the position outside the US and the intended position you're coming back to. Make sure there's nothing inconsistent with your H1B, because if your H1B is not filed for a management position, it's hard to say that you've been working in a management position. So lots of things could go wrong with that. So make sure you check it all out before you attempt it.
Shailaja is saying if it's a change in the company, I'm assuming that a change in the position or I couldn't get the question, but my company is changing the name. Shailaja, it's a bit complex question. When the company is changing the name, we need to understand, is there a tax ID number change though? If the tax ID number changes there, everything changes though. If there is no tax ID number, then it's a different issue. So we need to understand if it's just the people are, the company is changing the name, just like the way Facebook might be changing to Meta. That doesn't, that in that case, everything is normal, nothing changes though. But if the entire tax ID number is changed, the company changes to a different entity though, then it's a different issue.
Srini has an RFE on the EB3 485 and wants to know if you can request the interfile for EB2 along with that RFE. And what happens to the EAD that I received through the EB3. So it can't hurt to try to make the request to change your preference category to EB2 as part of the RFE response. Obviously, you have to respond to the issue raised in the RFE, and then along with that, you could add a supplement that says, please note I also have an I-140 approval in EB2. Please adjudicate my pending 485 in EB2 instead of EB3 if your final action date is current. And then once that happens, there's no guarantees that they will make that change based on your RFE response. You may have to follow up a number of times. And you can use the EB3 EAD because that green card, the 485, is still a valid 485, so your EAD remains valid. Whether you can use it to change jobs, now you have to wait another 180 days after you've interfiled.
Questions related to birth certificate, about the name, misspelling. You can submit you may have other documents that may authenticate your name, especially if you have the Aadhaar card, PAN card, ration card, election card, school certificates and all those things. And you may try to correct the name with the municipality though. That's one thing that I would recommend that you do, especially if your last name is not mentioned. That's not a major issue though. If your name is not mentioned though, I would strongly recommend that you get affidavits and also try to document with the other documents that I have told you, the Aadhaar card, PAN card, ration card, election card, school certificate, hospital records. Please have them ready though. Even if you don't submit to the USCIS, have them ready.
Abhi says, I downgraded from EB3 to EB2 last October. Obviously now EB2 is progressing. Will USCIS automatically work on my EB2 or should we interfile? If yes, what is the procedure? What are the fees? Do we do biometrics again? So I can guarantee they're not going to automatically do anything. So your 485 is tied to the I-140 that you filed with it at the time of filing. So you do have to take action if you want them to consider your application in EB2 instead. Your final action date has to be current. For the interfile, there is no process. That's what makes it so difficult. You can try, I have an article on those steps on rnlawgroup.com. There are many options you can try. Call customer service. If you can actually talk to a live person, they may ask you to submit your EB2 I-140. Written request is generally how our office does it. You may have to ultimately go through the ombudsman office or even a congressional liaison for help with that because there is no formal process. That's the difficulty.
How long after I enter into United States on F2 can I change to H1B? It's a bit complex though, guys. The technical rule says that if you do the change of status within 90 days, that means that you had an intent at the time of entry and you deceived it. But if you are coming from India with an intention to change after 91 days, still they can catch that thing. I mean, you cannot have an intent to file H1B and come on F2. Once you come here, you can change it. And then people may say, how do they know intent? Well, there are many different things. They will check into your WhatsApp record. They may already have your WhatsApp record. Who knows? They have your emails. They have a lot of different other things, methods that they find out. That's the reason we see a lot of some of these people who express their intentions to other people, but when they come to the CBP, they say, no, I'm coming only on F2 visa only. But when they check into their WhatsApp, emails, and other things, they find that information out. So be careful about these intentions, especially just because they say 90 days doesn't mean that you just go, you have the intent and you did not express it. It may be preconceived intent. That's just a presumption is that within 90 days. So be careful. They will check emails. They will check everything, guys. If you have intent of doing something else, you're coming on F2, that's not a good thing that you're doing. You may end up into trouble.
So Janya submitted biometrics 3 weeks ago, but nothing's been updated on the USCIS status. Is this common? How long will it take to update the status? Yes, it is common. They don't always update everything on that status. Sometimes it'll never update. So there's no set time period for them to update the case status after a particular action has been taken.
Venkat Narela has this question. After getting the GC, do I need to join the company which filed the GC? I'm assuming, Venkat, you did not work for the company, at least when the adjustment of status has been filed. No, you don't have to. This is a little bit controversial answer. People will say, what are you speaking about? Yes, Venkat, here is the thing. There must be a job offer for you, which they expressed it when they filed the I-140 or I-485J. Your intention was to join the company. Yes, your intention was. But if your intention has been changed because on November 16th at 5:56 Central Time, you heard from Rahul Reddy saying that if you don't join, you're still fine, your green card will not be taken, then you change your mind afterwards. You were about to join, but after this November 16th at 5:56 p.m., you change your mind. Yeah, that's fine. You can change your mind. I mean, there are a lot of times I make New Year resolution. I'm going to run every day 6 miles, maybe morning and maybe evening too. I'm not going to eat chicken fried anytime, never go to Chinese restaurant. Believe that, it only lasts for 1 week. After that, boom, I'm gone to back. So that happens. And if your intention is to join at that time, and if the company's intention is to take you, and now you or the company changed it, it's okay. There's nothing there. In the USCIS memo, it's very clearly mentioned that it's only the intention that counts. It's not the actual job that you do that counts.
Sairam had his wife's H4 extension and H4 EAD were filed concurrently, but the H4 extension has already gotten approved. The H4 EAD is still pending, and he wants to know, can she travel outside the U.S. while the H4 EAD is still pending? Yes, she can. The only requirement for the H4 EAD is that she be in the U.S. on the date of filing. Traveling after it's filed while it's pending should not be a problem.
Can we amend to change employer in I-140? My company is moving us to a different company though. Shailaja, if the different company has to be a successor of interest though, that means that the new company is taking the responsibilities and the advantages of the employees that are there on the I-140 application. There are certain guidelines for it. If the new company meets the guidelines, yes, the amendment can be filed. But if it's a completely different company, let's say, for example, Pepsi company is now outsourcing the entire IT employees to Deloitte. I mean, Deloitte is not related with Pepsi company in any way. So you cannot do the amendment. Deloitte has to file a fresh perm application in I-140. But within Pepsi, for example, they are moving it to, they form a different company and then they move some of the employees to a different company. They may meet the requirement required for the amendment. But if it's a completely different company, no, they don't meet it.
All right, well, I think we are out of time for today. Thank you so much for joining us. We'll be back again next week. We'll have some hosts filling in for us, as we're both going to be out next week over the Thanksgiving holidays, but we will be having our regular show on Tuesday at 5 o'clock.
Thank you, guys.